states against the Attorney General of the Federation, challenging the constitutionality of the Act establishing the Economic and Financial Crimes Commission, the ICPC, as well as the powers of the NFIU. The court held that the EFCC Act is not a treaty but a convention that does not need the ratification of the Houses of Assembly. Legality reports.
The plaintiffs had argued that the Supreme Court had in a previous decision held that it was a UN Convention against corruption that was reduced into the EFCC Establishment Act, and in enacting this law in 2004, Section 12 of the Constitution was not followed. Section 12 of the Constitution necessitated the majority of states' Houses of Assembly agreeing to bring the convention in before passing the EFCC Act, and others, which was allegedly never done. Delivering judgment, Justice Uwani Abaji, who led a 7-member panel of justices, read that the EFCC Act, which is not a treaty but a convention, does not need the ratification of the Houses of Assembly. A convention could have been ratified by member states, and the National Assembly can make laws from it, which will be binding in all states in Nigeria, as it is the case of the EFCC Establishment Act. It states that in a country like Nigeria, federating units do not have absolute powers, while the NFIU guideline is to present a benchmark and not to control the funds. Where an act of law is made by the National Assembly, like the NFIU and its guidelines, it is binding on all. Any other has been competently enacted by the National Assembly cannot be inconsistent. Where the National Assembly has enacted several laws on corruption, money laundering, etc., no state has the right to make law to compete with it. The investigative powers of the EFCC cannot be said to be in conflict with the legislative powers of the State Assembly. The court ruled that the NFIU guideline had not contravened the provisions of the Constitution to manage the funds of their state and resolve the issues against the plaintiff. All other justices agreed with the lead judgment, saying all the issues raised in the suit had no merit and are accordingly dismissed. The court had earlier dismissed all objections of the federal government to the suit filed by the states. The Supreme Court dismissed the suit in its entirety and resolved the case against the plaintiffs.
What the Supreme Court has done in essence today is to enhance the powers of the anti-corruption agencies and to validate their activities, and to say that within our jurisdiction, financial crimes and all manner of corruption-related offences will not be tolerated.
Kogi State was the original plaintiff in the suit, after which other states joined. This matter also caused trouble for some states, including Benue State, where the governor suspended the Attorney General for joining the suit without his consent. Celestina Area, TVC News, Abuja.
President Kashim Shettima